Welcome to Absolute Trust Talk with your host, Kirsten Howe. Absolute Trust Talk brings you tips, tools, advice, and interviews to help you build a reliable knowledge base on estate planning, business, and finance to start preparing for your future today.
Hello and welcome to Absolute Trust Talk. This is our podcast here at Absolute Trust Counsel. I'm Kirsten Howe, the managing attorney at our firm, and with me again today, Jessica Colbert, one of our associate attorneys. And we are doing a short little series on probate. Today, we're going to talk about how do we get a will admitted to probate. So last episode, we talked about what exactly is a will. Now we're going to take the next step. How do we get that into a probate? How do we get that probate started with our will? So Jessica, I'm going to let you start.
There are a few different requirements for getting that will admitted to probate. The first one is that you have to lodge the will. And what that basically means is you send the will to the county superior court and they just keep it in their records and it stays there forever and ever, basically. And the will that you send to the court does have to be the original. So the original wet ink signature, not a photocopy, the one that was actually signed.
That's an interesting concept. And we have clients a lot of times question that. When we say original will, it doesn't mean the very first will that was written in 1955. It means the current will, but an original, not a photocopy.
That's a good point. That just came up last week. Not the one from 50 years ago, the one from a few years ago, but was actually signed with a pen.
Right. Okay.
And then another requirement for the will to be admitted to probate is that the will does need to be authenticated. And Kirsten, tell us a little bit about how you authenticate a will.
Well, usually when we're doing wills, when we write wills for our clients, we write what's called a self-authenticating will. And that means that the witnesses to the will, the people who are present when the testator signs the will, they sign the will. That's what witnesses do. When they're signing their witnessing, they sign a declaration under penalty of perjury that this is all true. We saw this happen and we were there and that person signed this will. The point is they've made a statement under penalty of perjury verifying their witnessing of the will. That's called an attestation clause. We saw it and we are declaring under penalty of perjury. And the point of that is that when a court takes evidence that's given by a witness's statement, that it has to be under penalty of perjury. Yeah, I mean, we all watch courtroom shows. We've seen that. And they always have the witness, do you solemnly swear to tell the truth? They have to do this under penalty of perjury. Otherwise, it's not something the court can consider as testimony. And somebody has got to say, this really happened. So we want to get that done right in the document because we don't want to, 20 years later, have to bring those witnesses into court and make that statement. So it's very important to have that attestation clause at the bottom of the will. If it's a holographic will, what has to happen, we've had one or two cases. This doesn't come up very often, but we have had this where it's a holographic will, meaning, remember, if you watched our last episode, completely in the testator's handwriting. And usually when somebody writes a will like that, they don't put an attestation clause on there. They don't have witnesses. They don't bother with that. They're just sitting at home alone writing a will. So what we've had to do is have another person who is familiar with that decedent's handwriting and looks at it and is willing to, again, under penalty of perjury, say to the court, yes, that is written by that person. And again, we do that in writing. It's called a declaration. But somebody's got to actually authenticate that that is the person's will and that is their signature.
So what about in a case where it's not a holographic will? It has the two witnesses, but we don't have that attestation clause under penalty of perjury.
Like I said, I alluded to, we would have to go and find those witnesses and get them to actually submit some sort of attestation clause. I think that's part of why they have two witnesses, because then at least you have a shot of finding one of them. But I don't think I've ever actually had to do that. Or I think we had a case where we thought we might have to do that. And then there was another way that we went forward. But you just don't want to be in that situation because you might not be able to find these witnesses. They don't always have their name typed below their signature. We always put the name typed below the signature, but it's not a requirement. And so then you're just going off the signature, which if you saw my signature, you can read my name. But a lot of clients, you can't read their name.
They'll never make it out.
Right.
And it could have been signed years ago.
Right.
Trying to track someone down years after the fact just gets harder and harder.
Right. So you definitely don't want to make that mistake. You really want that witnesses under penalty of perjury, ideally they print their name and they sign their name or somebody prints their name. That's the best because it covers all the bases.
Okay. Earlier, I talked about how we need an original will. What about a case where we don't have that, but we do have a photocopy of the will?
Yeah. So that is a problem because there are two ways in the law to revoke a will. One is you write a new will that says, I hereby revoke all prior wills, which is what we always do. Every time we write a will for a client, we say that right in the will. The other way to revoke a will is to destroy it, rip it up, light it on fire, whatever. But if all you can come forward with is a photocopy, it raises the suspicion that this decedent destroyed their will and there really is no will. So you do have to go through a procedure where you submit documentation, testimony saying that there is a lost will. There's a lost will because we can't find the original. All we can find is photocopy. And you've got to have, basically witness testimony to support that. Like, I know my uncle had a will. He showed it to me 3 days before he died. I don't know where it is, but this is the copy of it that he showed me in the folder with the original. And, whatever you have to do to say this is actually his original will. And as we're going to talk about probably in a future episode, the family members have an opportunity to object and say, no, that's not, he destroyed that will. That's not his will. And that's why you can't find it anymore. Or something, whatever they want to say. So that's a challenge. And so if you're listening out there and you have an estate plan, it's very important to keep track of that original will. Don't lose it. Don't stick it in a safe that nobody knows about. It's very important to keep track of that original will.
Yeah.
Okay. So hopefully that's a little bit of knowledge that I don't know how you're going to apply that in your daily life today, but it might help you down the road. And Jessica, thank you. And we are very glad that you were able to join us today. And we look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcouncil.com. Thanks again for listening. We'll see you soon.
This podcast is not meant to take the place of legal advice from an attorney and does not create an attorney-client relationship. If you do have a legal question or issue, please consult with an attorney.